you explain, and I think maybe this would address Justice Kavanaugh, he'll correct me if it doesn't help. What is it in 924C that permits the two convictions to run consecutively? So I think you're saying an intent to allow for dual convictions is what you need to have Congress show, and not speaking only to the length or timing of a sentence, correct? You need more than length or timing. So what is it in 924C that permits a dual conviction?
Right. The dual conviction in 924C1A is for gun possession and the underlying crime of violence or drug trafficking offense.
Okay.
And Congress is very clear you can stack those punishments. And if you do, in fact, impose a sentence under C in that scenario, that sentence will have to run consecutive to the underlying offense. That is not this case, Your Honor.
All right. But if it's dual convictions, generally, you have a drug offense for carrying a firearm. You get a sentence for that. You have to run this consecutively. What is it in the statute that you say makes it clear that it's speaking not just about punishment, but about conviction as well?
Well, when it talks about punishment, conviction, sentence, these words in the case law are kind of used interchangeably. The idea under the double jeopardy clause is that you can't be punished twice for the same offense. We know here we're talking about one offense. So the question is there any clear indication that Congress wanted someone like Mr. Barrett to get multiple punishments? And I think it's important to remember that when Congress wrote 924J, the statutes didn't look like they look today. In 1994, 924C's penalty was a fixed 5 years. It was not a minimum. So Congress found that insufficient. They're like, if you kill someone, you need more than 5 years in prison. It wrote J to allow for the death penalty and up to life in prison. It rejected the proposal that a fatal shooting should be subject to C's multiple punishment regime. And this court explained in Laura, it designed J to account for the seriousness of killing by itself. There's no indication that Congress thought someone sentenced to death under J or up to life in prison should get 5 years on top. What's the point of that? There may be something strange nowadays when we look at C saying it's a minimum of 5, and why would Congress want to have a minimum for gun possession but not fatal use? But this court unanimously rejected that argument in Laura. That was the government's argument there. If you have a minimum for possession, you got to have one for lethal use. This court said no, there's no indication in the statute of that. Congress didn't clearly indicate that that's what it wanted.
Well, when we